A legal showdown could redefine Captiva's charm. The South Seas Resort wants to pave the way for a new era of growth and expansion, but the Captiva Civic Association has been fighting them in court, trying to stop that expansion. At the heart of this fight, density. How many units can South Seas get permits for? Well, the two sides were back in court today. Wink News reporter Amy Gallo joins us live from downtown Fort Myers now. Amy, we've been reporting on this back and forth for months now, so where do we stand tonight?
Tonight, the judge upheld his decision to deny the county and South Seas their motion for a summary judgment. Now, this is a decision that favors the Captiva Civic Association. Now, you're probably sitting at home thinking, what does this mean? Let me break it down for you. A summary judgment is a court decision made in favor of one party in a lawsuit without a full trial. Essentially, it allows the case to be resolved without going through the typical trial process. This week, the judge denied South Seas and the county's motion, and today he heard the Captiva Civic Association's motion. The judge did not give an official verdict just yet, but he did say he stands by his decision from earlier.
We are very, very pleased that the judge reinforced our position that the settlement agreement that we entered into over 20 years ago in 2003 is valid, it's clear, and it's enforceable.
So what exactly happened in 2003? South Seas old owners entered a mediated settlement agreement. It capped the amount of permits allowed for dwelling units in South Seas at 912. Well, according to court documents in 2023, South Seas' new owner applied to rezone the resort property from 912 units to 1,271. Lee County agreed. The Captiva Civic Association then sued Lee County and the South Seas Resort, saying adding those units goes against the MSA. Today, South Seas argued they are not asking for more than 912 dwelling units, emphasizing the use of the word dwelling instead of hotel units.
We asked this court to grant summary judgment against CCA because it did not prove that the MSA is an enforceable restrictive covenant because it does not run with the land and it does not bind successors in interest.
The judge gave both sides a deadline next Wednesday to provide him with some additional court filings. After that, he is expected to make a decision on whether the Captiva Civic Association will be granted their summary judgment. And we will find out about that a couple days after that Wednesday deadline. So as soon as we know more, we'll be sure to bring that to you. But for now, live in Fort Myers, Amy Gallo, Wink News.